Yes, good morning, Miss Noor.
Good morning, my lords and my ladies.
Well, thank you very much for your excellent skeleton arguments and the way in which the case will be prepared. We're very happy with how that's all been done. We've read the key documents in the case, skeleton arguments, judgment, relevant authorities, some of the background documents in the supplemental bundle. So we're pretty much on top of the issues. Have you had a chance to discuss how you're going to divide? We've got the morning. We think pretty confident we should be able to deal with it in the morning. Have you had a chance to discuss, Ms. Hoban, how you're going to divide the time?
We have, and I propose I will take no longer than an hour and 15 minutes.
Right.
And my learned friend up to an hour, and I will have a very short reply if needed.
Thank you. Right.
So I appear for the appellant,
yes.
And my learned friend, Mr. Holden, appears for the respondent, Secretary of State for the Home Department.
Yeah.
It sounds as though you do have the three bundles, the core bundle, supplementary and authorities bundle.
Thank you.
And that you've seen the skeleton arguments.
Yeah.
So just in summary, this is an appeal against the costs order of Upper Tribunal Judge Kabede, dated the 5th of August and awarding 75% of costs instead of the full order that was sought. And that order was made despite the Secretary of State, after permission to apply for judicial review was granted, deciding to reconsider the challenge decision and to reverse it by granting leave to enter. The essential reasons given by the judge for the 25% reduction are that there is some merit in the Secretary of State's view that post-decision evidence was relevant to the decision to grant.
Shall we get out the decision?
Yes.
So we've got the precise reasons in front of us.
Absolutely.
I think it's, from memory, it's tab 11. It is tab 11.
It is tab
And
11,
the key part is really paragraph 3, isn't it?
Yes.
Yes. Or we may want to mention 2.
Yes,
3 is where
precisely.
the 2 is the decision.
To summarise
3 is the decision.
what she understood
Yeah.
the new evidence to be,
Yeah.
and 3 summarises the reasons. It seems to me that there is some merit in the respondent's view that post-decision information was relevant to the decision to grant entry clearance. However, having said that, there's also some merit in the assertions made by the applicant about delays causing an increase in costs. In all the circumstances, while the applicant can, to some extent, be regarded as the winner, applying emin Croydon, there are matters properly raised by the respondent which reduce the entitlement to costs.
I've underlined the words to some extent there.
Yes.
Ms. Noor.
Yes. I will address you on that, because there is a query about whether that is an error as well.
Yes.
And one of my pleaded points is that if the judge was saying it was not a Category 1 case, then that is an error in the judgment. So there is no dispute between the parties as to the relevant test that this court must apply, and a cost decision, which is a discretionary decision, should only be interfered with on appeal if the appeal court is satisfied that the judge below has either erred in principle in her approach or left out of account or taken into account some feature that she should or should not have considered.
Yeah. Lord Neuberger summarised that, didn't he, in the Croydon case?
Yes, or that her decision is wholly wrong because she has not balanced the various factors fairly in the scale. I have cited Tesfaye at paragraph 13.
Maybe it's Tesfaye rather than Croydon. It's certainly established principle.
Yes, it's established principles. It's page 54. It's tab 4, page 54 of the authorities bundle.
Okay.
If you, I don't believe we need to turn it up, but really so that you have it for your for your judgment. In a nutshell, the appellant says the decision is unlawful because, and first, this is ground 1, the judge failed to properly direct herself and take the correct approach to costs in view of AB being the wholly successful party who complied with the PAP. It's a Category 1 Emin Croydon case where we say there's a heavy burden on the Secretary of State to demonstrate that AB should not get all of his costs. Second, and this is ground 2, even if the judge's analysis were correct, in other words, that post-decision evidence was relevant to the decision to grant entry clearance, that is not a good reason in the circumstances of this case to have reduced costs. The Secretary of State's decision to reconsider was firstly itself success in the judicial review, and even if the new material was relevant, it didn't justify a reduction. In any event, that new material that was produced and that was, in fact, of relevance to the decision is not the type of material that could justify a reduction. That's because it was either material that was submitted at pre-action stage, insofar as it was relied on, explained why the challenge decision was unlawful and reasonable and wrong. Thus, not only was it not was material not of the type that could possibly justify a reduction, but the material that prompted the reconsideration and reverse. But if it was going to prompt a reconsideration and reversal, it should have done so at pre-action stage. There's no reason why it took till the point of detailed grounds. The other type of material, which was post-lodging, was responses to questions put to the appellant by the Secretary of State when the Secretary of State was reconsidering the decision. But those questions arise out of a reanalysis of pre-decision material. So again, firstly, they're questions that the Secretary of State wished to ask. We're not saying she shouldn't have, but it shouldn't have reduced costs. And secondly, that they arose, they were questions about that she could have asked before. They weren't questions about new material that she hadn't had sight of. So we say that the judge's finding is flawed in principle and failed to take relevant factors into account. Ground 3 is that for these same reasons that the balance wasn't properly conducted.
Yeah.
So first, I plan to take you to the key background material. And that's important because of the dispute between the parties of the relevance of the pre-decision material. And it's necessary to show you what this material was and which bits of it were actually relied on. I was then planning to take you to the decision, although we have looked at it already, so that may not be necessary to look again. And then I will make brief submissions on the 3 grounds, but I hope to have made good my points when we go through the material. And finally, I will address a couple of points made in the respondent's response and respondent's notice. There's overlap in those. So the key facts are in my skeleton at paragraphs 5 to 20. And in brief, the appellant is an Afghan national. He was a 5th-year medical university student living in Ukraine, married to a Ukraine national when the war broke out, and his wife went missing in the war when she went to a particularly dangerous part of the country where her parents lived just before the war broke out. Now, he applied under the Ukraine schemes to join 2 brothers who were in the UK, and it's now accepted that if he was in a subsisting relationship with his wife when she went missing, he failed to be granted leave to enter. There was an original refusal that did not dispute that the relationship was subsisting, but had refused him because he was not Ukrainian. Secretary of State agreed to reconsider that decision after a previous judicial review. And then, prior to taking the challenge decision in the current judicial review, the Secretary of State interviewed the appellant with respect to some discrepancies about the account of how he became separated, i.e. physically separated.
On 2 occasions.
From his
presumably
wife.
by a video link, because your client
Yes.
was in a refugee camp in Poland.
I think by then he was in Luxembourg. He'd moved from Poland to Luxembourg.
I was going to ask you about his actual movements. So
yes, he went.
He was initially in Poland.
He was initially in Poland, and then he ended up in Luxembourg.
I'm sorry, I
After
should have spotted that. I missed it.
No, it's
When in the process did he travel to Luxembourg? At some point.
I am not 100% sure. I will check though.
Well, that's my mistake.
It should be in the grounds of judicial review.
I'm sorry,
has
I missed that.
No.
Yes, carry on.
But he was at the material time, which is the time he was filling in the form. He was in a refugee camp in Poland. It was just after the war had started. He was interviewed, and he had already though addressed those discrepancies. He'd acknowledged them and said, he'd explained that he'd had help filling in this form by someone who had a laptop in the refugee camp. He spoke quite good English. He was studying medicine in English, but obviously it was not his first language. And he spoke a little bit of Urdu. The man who helped him complete the application spoke a little bit of English, and his language was Urdu. So they could communicate, but it wasn't perfect. And effectively, he explained how he believed those discrepancies between the two forms had arisen. It's apparent from the interview that the Secretary of State was considering, given the questions that were being asked, whether she accepted the account of his wife going missing in the war. And therefore, his solicitor wrote to the Secretary of State following the interview, saying that if now, because this would have been the first time credibility was raised, if the respondent was going to raise credibility, that in accordance with common law procedural fairness principles, he should have the opportunity to respond before any decision was made. And the reference for that is at page 302 of the core bundle. It's the very last.
What's the date of that letter?
So that is paragraph 33 of this
14th
letter.
of February, was it?
Yes.
That's right. Yes.
Precisely. Starts at 298.
Thank you.
And that's a letter that addresses some points in the interview, raises some concerns about the record, and asks for that opportunity. Secretary of State, however, on 6th of April 2022, issues the refusal decisions, and there are two of those. They're under each limb of the Ukraine scheme.
There are two schemes, aren't there?
There's two schemes, precisely. And forms have been put in for both schemes.
Yes.
And it's the HUSS, the Homes for Ukraine scheme decision that actually deals with the dispute about...
So longer, the reasons are longer under the HUSS scheme, and they specifically mention and focus on the issue of the subsisting relationship.
Precisely.
And they express the conclusion the relationship was neither genuine nor subsisting.
Precisely. And that starts at page 188 and goes to 190. And there are, you see in that decision, there are lots of reasons that relate often to what was said in the interview. And I will show you, this matters because that is what the evidence, this new evidence that was put in at pre-action stage, the parts of it that haven't been discounted by the Secretary of State, effectively respond to the reasons in this letter, saying, well, it's not fair that you said this because X, Y, or Z. And I will show you that momentarily.
Yes.
So on the 17th of May, 2023, a very, sorry, that can't be right.
This is 17th of May, the PAP letter was sent.
Yes, the PAP letter was sent. Sorry, the decisions are 2023, not 2023.
The second decision was the 6th of April 23.
Precisely.
And the PAP letter was the 17th of May.
Precisely. And that's at the supplementary bundle, page 3 to 32.
Yep.
It's a detailed cap. I won't take you through it because it really goes through pretty much all the points in the grounds. It's not it's a PAP that fully sets out. I don't believe there's any dispute about that, but you can see it it runs to 33 pages and
Yes.
goes through all the points. It goes through the background, and then starting the grounds are in a slightly different order in the PAP. The ground 1 is at page 12. That's meeting the requirements of the HUSS. Ground 2 in the PAP meets the requirements of the UFS, the other scheme, the family scheme. And then ground 3 is the unlawful assessment of credibility, and that goes through almost every point that is then raised in the grounds, and that's pages and pages of the PAP, because each point in the decision that runs to page 19, and then there's ground 4, the Article 14 argument, and then the Article 8 argument,
yes.
and then the discretion argument, which encapsulates all of the grounds as effectively, if you don't grant me in the rules, you should grant me outside the rules for lots of reasons set out
Yes.
above, effectively. So the evidence enclosed with the PAP was responding to the reasons given for disputing the appellant's credibility, or it reinforced pre-decision evidence. And it was as follows. There was the appellant's third statement, which I do want to show you. So this statement starts at page, it's in the supplementary bundle. And
Supplementary bundle, right?
yes, and it starts at page 34.
Tab 2.
So what there was a supplementary bundle, 2 witness statements from the appellant's brother and roommate, and a new medical report. Now, the 2 witness statements, there's disclosure showing that the Secretary of State discounted those as biased because they were people giving reports of what they had been told by the appellant. And then there was an independent medical report, but that the GLD has told us in correspondence was not the reason for the reversal.
Well, they have now, but originally they said
Yes.
that was the reason.
Well, precisely, it changed. But the third statement, I should say,
So this third statement was included within the PAP letter.
it was with the PAP. All of the evidence was with the PAP, apart from the answers to the questions. But that didn't have new evidence that responded to the questions. I'll show you. But the third statement is what's important, because that's the bit that hasn't been discounted. No one's ever said that this wasn't relevant
So
to the...
your point is, this was information which was provided with the PAP, was therefore before
logic.
before the claim was issued and before any PAP response was
Precisely.
delivered.
And then there was a 5-week period before the claim was lodged
Yes.
to decide what to do with the PAP and the information with it. So, but also, when you look at the statement, the first section of it, at paragraphs 3 onwards, describes, is effectively relevant to how upset he is about the decision and the urgency, how he's still seeing a psychiatrist, he's living, he's having a difficult time. It's effectively an update, but all relevant to why he...
Well, what in particular, was there information in this you say was particularly relevant to the question of the subsisting relationship issue?
Yes, well, what happened is, then you see at paragraph 8, he starts to address the refusal letter.
Yeah.
And he basically then goes through, which is similar to the PAP, but he's effectively providing the evidence, the same points that are made in the PAP. He's, in a sense, backing them up by evidence. So you can see you can see for it, and that runs from 8 to 76, paragraphs 8 to 76 of this statement. So first he explains the background, effectively, what was said in each of these forms that caused the dispute, how at paragraph 14 he explains that in his first FWS's first witness statement, that's a pre-decision statement. He said, I already explained, before, that was put in with the original application before any decision was made. He explained how he thought the discrepancy arose, who had filled in the form, about the language, and that he thinks it's pretty obvious that his account was clearly somehow misunderstood, or the way it was written didn't convey it properly. And he confirms again that he didn't check it at the time. And then he was then assisted to complete the HUSS form by a man in Britain, and the correct account is in the form. And so he then addresses that, and explains he didn't even know there was the mistake, etc. He goes through the evidence that was before the decision maker, showing that he told an MP the account of his wife going missing. He'd repeated the true account that's now accepted as true to lots of people, and the correspondence was all before the decision maker. So he was looking for his wife. There was correspondence with the Polish Red Cross, trying to find her in the war. There was this MRPL Life website, another organisation trying to help find people, where he was saying, I'm looking for my wife. There was medical letters from treating doctors, where he explains that he'd lost his wife in the war. So there was lots of material before the decision maker, and he's going through all of that in the statement, and explaining that background. Then at 28, says he wants to address the points in the refusal letter, and he starts doing that, and that starts at page 39 of the bundle. And you can see, for example, one of the things that had happened is that when the person, Abdul Wahab, was completing the form, something happened where two forms got submitted within seconds of each other.
Yes.
And that's something he wasn't aware of. So the evidence is, I didn't even realise that had happened until you relied on it in this decision. And then, for example, he addresses this point about the two multiple languages. So you'll see what he does at 38 is quote from the refusal, where the refusal rejects his account, and where they describe them as speaking two mutual languages.
Yes.
And he says that's not accurate. I explained in my witness statement that Abdul Wahab spoke Urdu and some English, and I speak English and some Urdu. The fact that we had to use both languages is because we were not fluent in both. So plainly there was a problem. Then
would you forgive me if I
Yes.
if I just interrupted you, just to focus perhaps on the key, what may be the keys?
Yes.
Is that all right?
Yes, of course.
In the forms, and I hope this is not being too simplistic, in the forms, both forms, your client describes his relationship status as separated.
Yes.
It would help me to know at what point he gave explanations for what he had said in that respect.
Yes. That was in his first witness statement. That was not only before this decision, but I had mentioned that there was an initial decision that then got reconsidered that didn't raise any issue with the relationship. And that statement is in the core bundle. So the core bundle has the application and the evidence with it.
Yes.
The supplementary bundle has what came with the PAP. So he had explained that he had corrected the form. I will show you where. Sorry, that's the second witness statement. I believe. Sorry, yeah, the first witness statement is at 226. of the core bundle, and
Right.
he describes in that, that's dated 25th of May 2022.
Yes, tab 30 in our core bundle.
Sorry, yes, tab 30.
It's paragraph 29. He didn't read the application. I wish to clarify my wife and I were physically separated, not legally separated. That's the point.
Yes, that's the point. So he'd said that, I mean, before any decision was made, once the solicitor, once the solicitor looked at the forms and asked him why there was this difference, he'd explained in a witness statement how he'd fled, how they became separated. They did argue he didn't want her to go. It was just before the war was starting. She wanted to go and get her parents. And he said, no, it's too dangerous. Don't go. They have an argument. She goes, despite him not wanting her to. And he never sees her again.
Okay.
So that's what he had explained.
And was there any further information, forgive me for interrupting you, was there any further information about that? In the
There was...
response and or the third statement which accompanied it? The PAP letter, sorry.
Well,
Forgive me.
what happened was there's a statement that explains the discrepancy. There's then the consistent account given to the MP in all the correspondence that the appellant writes himself when it's something he's writing himself to the Red Cross looking for his wife or to the doctor when he is going to get treatment for his mental health. He describes what had happened. But then there's also the interview. So then the Home Office have the interview with him, and the interview transcript is at page 284.
Yes, tab 51.
Tab 51. And that interview, he again gives a consistent account. Now, we did raise some issues with this. For example, the record is often in third person, so it's not... These records are supposed to be an actual account of what the person said, and we had asked to hear the recording because we were worried that in some places it was more like a description of what he said. But that doesn't matter because there isn't anything... We corrected any small issues, but effectively he explains, you can see at 31, question 31 on 288, where he's explaining about the argument. And you can see at 36 he's crying. I mean, this is a man who is absolutely devastated by the loss of his wife. He has nightmares about it all the time. That's recorded in the medical evidence. It was not, certainly in my submission, it was very obvious that there had been a mistake, and it was obvious why that happened, and he had explained it repeatedly before the decision. So, and I should say, obviously, the respondent, in fact, accepts this, but it's true. I understand why you're asking me, because this is not as though it's not as though the PAP was the first time. My learned friend says there was lots of new evidence about how he went missing from his wife, but the same account was given since long before the decision. What was in the PAP response was a response to, in my submission, how his evidence had been twisted, and I'll show you that. But for example, it says somewhere that he said he was. It asserts that in this interview, it says that he was dictating the information for the form to Abdul Wahab, and obviously dictating has a particular connotation, but he never used the word dictating. All he says in the interview is, I told Abdul Wahab my account, and he put it in the form.
Yes,
So,
that's what he says at question 65 on 294.
Exactly. So it's not. So what he addresses in the statement is not new evidence. It's saying you have not taken a reasonable approach to my evidence. What the
Yes.
way you've analysed the material before you isn't fair, and you've come to the wrong conclusion because of that. And that is the bulk of that statement. So if we could just go back to that, it's page 40 of the supplementary bundle. You can see that, I mean, he sets out answers to the interview. He relies on it and says, I didn't say I was dictating it. There's the Secretary of State claims that at question 67, he said they had no issues communicating, but that was not what the question and answer said. So this is the type of thing. This is a painstaking response, point by point, showing why the refusal is unreasonable. And it's only right towards the end, in response to an allegation that he didn't try to contact his wife through social media, and having explained that she didn't use Facebook, but he explains, I did try and find her using social media. This is at 67. And he exhibited some additional screenshots from which he had posted back in May 2022, saying he was looking for his wife. But as I've said, there was already evidence of that nature before there was evidence of him asking the Red Cross to help him find her in other groups. So he provides some further posts where he's saying, like, my wife is missing, can you help me find her effectively? And some messages where he was talking to the HUSS sponsor about ways that he could try to locate her, and a random person who responded to the messages where he describes his life, feeling like his life is over because his wife went missing. So that's the only new evidence, but it isn't new evidence in the sense that it's all in the same vein as the evidence that had already been provided. And then the statement ends. So that is the witness statement. And as I say, that's the only document that is not directly said not to be that could be relevant based on the material we have. You can see about the other statements.
I'm looking at the screenshots then, if I could
Yes,
just
of course.
focus on these.
Yes.
We have at Exhibit AB5 to this statement,
Yes.
we have a screenshot of, more than one, is it?
Yes.
Well, it looks more or less it's the same.
I think there's
the green box in the middle
Yes.
is your client
Yes.
on in I think it's May 2022,
Yes.
contacting something called foreigners in Ukraine, or is that the website? That's
It's called a Telegram group. I think they're groups with lots of people in it, and there's 3 different ones he's posted this on.
These are like WhatsApp groups, but it's a different messaging system.
Exactly.
So there's a number of people on a group. There seem to be thousands of members on each of these.
Exactly. I think people were trying to find. I think it's something that's used a lot in that part of the world. It's more common, I think,
Yes.
as I understand it. And there's lots of people trying to find their missing relatives in the war using these groups.
Yes.
And then there's messages with the sponsor. But as I can show you, there were similar material, because one of the things that was said was that he hadn't, there wasn't evidence of trying to find her. But if you go to the core bundle, and this has the evidence before the decision maker, you can see he had already provided evidence 243. It's document 35
In the supplemental bundle.
in the core bundle.
Core bundle, sorry.
So the core bundle has the material that was already before the decision
Yes.
maker.
Okay.
So he'd explained that MRPL Life was a way to look for residents, like people that they couldn't find during the war.
Yeah.
And you see he put his wife's name, where she was from, and explaining the same story. And this was all put to show, well, that he was trying to find her and that he was telling the truth.
Yes.
So, and then there is then the contacts. He was given, the MP here, in fact, gave him the contacts of the Red Cross when he wrote to Ben Wallace MP about
Yes.
his account.
So Ben Wallace he wrote to Ben Wallace as MP rather than as
As MP, I believe Ben Wallace was the sponsors. He was either a sponsor or the brothers MP, and they were trying to help him. And he was saying, "I'm desperate. My wife's gone missing."
Thank you.
And he, and then so they give him. There's details about how you search for people, the contacts of the Polish Red Cross, and then we get on. Sorry, there's medical. I mentioned medical evidence. You can see it 257.
Right.
He's been looking for his wife. He's very depressed, anxiety, flashbacks. And then it carries on because then there are other emails with the. We just go to the. There are other emails with the Polish Red Cross at 270. Obviously, the Red Cross is the most formal and main, and indeed was what the MP had said. So you see, he's. At 270, these emails from July 2022. Julia is the contact at the Red Cross. I want to ask about my wife. I'm so much depressed and mentally disturbed. I'm not feeling well. I'm always thinking about my wife. Please help me. If you get any information, please let me know. And you see he's following up on these requests and the emails. Back and forth with this woman Julia at the Red Cross. You see,
Right.
and there's reference at 270.
So this information was
All
before
before
the,
the
was
decision
before
maker.
the application,
Yes,
before the second decision.
before the first decision. In fact,
Before the first
yes,
decision.
it was before.
All right.
I think we've got the picture. Miss Norman.
Yes. So while yes, there was he then produced a couple of more bits of evidence in the same vein. That was the bulk of the statement. So then a PAC response is received, and that is received after the claim has been issued.
Yeah.
And you can see that's on the 28th of June. So that's there have been 5 weeks. There was request for more time. The applicant was saying, we're going to lodge if you don't respond. The claim is lodged on the 22nd of June, and then on the 28th of June, the PAC response is received. And that is at tab 11, page 84 of the supplementary bundle. And it maintains the decision and it says, it doesn't make any mention of wanting to reconsider, ask more questions, anything that happened later. And that, in a sense, my submission is that really should be the end of it, because not only is the evidence in any event in my submission not of the type that would warrant a reduction in cost, but if it was going to provoke a reconsideration, there's absolutely no reason why it didn't do so before the claim was lodged. And that's the whole point of the PAC. And there's never been any explanation for that. So then the decision is challenged on 6 grounds.
Yes.
The grounds are in the core bundle at 167 to 180.
Can I just interrupt you?
Yes,
Sorry.
of course.
You showed us the PAC responses 28th of June 2023. The claim form was actually issued before that.
Yes.
20th of June.
Yes.
How long does the protocol allow for responses?
14 days.
14 days. And the Secretary of State had asked for an extension of time. Presumably, the Secretary of State at the time was inundated with applications.
Well, the Secretary of State, you're supposed to give reasons for why you want more time.
Yes.
And we kept saying, you're not giving us reasons. Now, this was in a context where the previous judicial review had settled with a recital saying, we'll give you a decision by X date. I don't now remember the date. It was months later. Because of this decision to interview, it took a decision that was supposed to come in early 2023, or even late
Didn't come till
2022, didn't come till much later.
Yeah.
And so there had already been lots of complaints about delay. There was the whole previous judicial review. This is a client who's really unwell, who's really desperate, and in extremely poor mental health and really distressed and desperate to be with his family. And there's delay. So hence why I showed the PAC does address how important a quick response is. This is also in a context where there has been a previous judicial review.
Yes.
Secretary of State knows this case very well. They've interviewed the client. And we actually said, can we have the opportunity to address this if you're going to raise a dispute in accordance with duty and all those authorities about.
My Lord's question was really
Yes.
pointing out that the Secretary would have been very busy at this point.
Well,
This was, of course, 15 or 16 months after the Russian invasion, wasn't it?
yes. Well, it wasn't. There was, in my submission, there wasn't any particular reason why the Secretary of State couldn't have responded in time. But when she asked for more time, we actually ended up waiting 5 weeks. But
Did you agree to her having longer? What's the position?
Let me just check if that is. I've got it in the grounds. I think we did not agree to more time. Let me just show you where it is, the account. So, yes, we had. I could certainly get you that correspondence, but effectively,
Well, can I just ask you this? Is it your submission that you weren't premature in launching the proceedings?
No, we certainly weren't. I mean, obviously, you have to lodge a judicial review without delay.
Yes.
If you do want more time, the protocol says you should explain why.
Yeah.
It's not unheard of to get very standard form letters that just say, we want another 2 weeks, we want another 2 weeks. And that was effectively, and we said, no, in this case, there needs to be a good reason.
But your point really at this stage is not whether or not you were right or you should have given a
Yes.
agreed to an extension. Your point is that whether or not you agreed, there was a 5-week period
Yes.
on your cases. During that period, the Secretary of State had plenty of opportunity to address the issue
Yes.
in the way that you say, I'm not sure if it's he or she at that time, they should have done, and didn't, and only did it at a later stage.
Exactly, but not only that, it was negative. So she ended up taking the time she wanted to take, and we did get the response. It happened to arrive after we'd already lodged. I should mention actually that, with something I forgot, if you look at the grounds at page 60 of the bundle,
Core bundle.
you can see what had happened, and the fact
160.
160, yes. So what it was, in fact, if you look at 33,158, just so you do understand the background, the order from the first JR was sealed on the 6th of December.
And originally you were going to be, you were told that a new decision would be made very
12th
quickly.
of December.
And it wasn't made for several months.
It wasn't made for months. And actually what happened is there was then a JR, which is on paragraph 42 of the grounds on page 160, saying a JR was lodged to challenge that delay. And then that settled when the refusals are then received.
Say settled. You withdrew it.
Yes, it withdrew. Yes. And then there was the PAP.
So the PAP was on the 17th of May. You are supposed to allow 14 days, which takes you to the 31st of May. In fact, you waited until the 20th of June, which is almost another 3 weeks. So you waited almost 3 weeks beyond.
Exactly.
And you say that's not premature.
Yes.
Because the Secretary of State's had 5 weeks and she hasn't responded within that time.
Yes.
And so you were entitled to launch your third set of proceedings.
Exactly.
Yes.
And then when we get it,
It's still
we may be
maintained.
having a different argument. If we'd got it 3 days later and it had
she
said, I want to
now I want some
reconsider."
more information.
Exactly. If she'd said, I'd like to ask you questions, I need to look at this again, then I could see we might be having an argument. We'd really be focused on, did you lodge too soon? Should you have given her time? But actually, that's not what her response said.
So quite an important part of your submission, therefore, is that the content of the PAP response, when it eventually arrived, was simply to adhere to the existing position
Yes.
and not raise further questions if they had further questions, which were in fact subsequently raised.
No,
They could have been raised at that. They could have been raised as
then.
PAP response.
Could have also been raised when the summary grounds, because then there was a permission stage.
Yeah.
So
Yes, so presumably, if the response had come in a week after you'd issued your JR saying, hang on a minute, we think we want some further information,
yes,
you could have put the JR on hold until the further information had been provided and a decision had been made.
absolutely.
Whereas what actually comes in is saying, no, we're not reconsidering, the decision's perfectly fine. And so you then have to take it forward to the permission stage.
Yes.
And it's only after permission is granted that there is,
Yes,
well, in that case, we want some further information. And we'll ask you some questions.
Exactly. It's the day the detailed grounds are due that we get a request for more time for the detailed grounds, because the Secretary of State, and I want to show you this as well, because what they actually say is we want more time because we're worried we're going to lose the JR if you decide it based on what's in front of you. That's what they said.
So it was only after permission was granted and on the day the
detailed grounds are due.
detailed grounds of defence.
That an extension is requested because they want to make a supplementary decision. That's what this said, and I'll show you that in a moment. So yes, this is critical because it's in some ways the detail is, in my submission, the icing on the cake, if you like, of what that evidence actually was. But in a sense, it doesn't matter because applying butter and the whole point of what those cases show is that if you comply with the pre-action letter and you raise your points, then there is the opportunity to address them at that point.
Yes.
And if the Secretary of State doesn't take it, then she has to pay the cost.
And that's the whole point of the pre-action protocol, it's to avoid proceedings.
Exactly. And there's
And
nothing.
presumably, if in response to the pre-action protocol, the Secretary of State said, OK, we need some further information and we'll make a supplemental decision, you never issue proceedings. You don't get your costs of the PAP. You just have to write those off.
Exactly. Of course not. That's how it works.
But if the response either doesn't come at all, or when it comes, it's to say, no, we're standing by the decision, then you say you're entitled to issue the proceedings, and the costs really fall to be borne by the Secretary of State.
If she then later turns around and says, actually, even if it is based on further material with the PAP, it doesn't matter. But as I showed you, the type of material is not. So yes, precisely. I mean, it really is. This is why, in a sense, we say it's a really open and shut case. We say it's a case, costs shouldn't have been disputed. That's what.
Well,
I mean, that's because the problem is then you get into with this type of situation. We do say that costs shouldn't have been disputed, or it should have been really transparent what actually caused the new decision. Because this is a case where a judge is having to. This is not a judge that's heard the case. This is a judge who has to make, no doubt,
There is no hearing.
There's no hearing. No. So the judge is making a cost decision on the papers, having not heard the case, having no familiarity.
Well, that's why
the case.
It can always cause problems if a case is withdrawn or settled in circumstances where it's a compromise in some sense. And one of the points which you haven't yet addressed is the suggestion that when the judge says, to some extent, your client was the winner, that suggests it might not be an outright win.
Yes.
It might be you've got some of what you were asking for, but not all of it.
Yes.
And those can give rise to great difficulties because the judge hasn't heard the case. But I think ground one is that actually it was a straightforward win.
In a sense, we were so overwhelmingly, we were in a sense unusually successful because we did get our ultimate remedy,
yes.
which was the grant of
not
leave.
just a reconsideration, which is Lord Justice Lloyd Jones, as he then was, I think it was, said in Tafsir, is all you normally get.
Yes, exactly.
You actually got a complete reversal of the decision.
We got a reversal decision. We were seeking that. We did say there was only one. Ultimately, the judge was going to have to decide if they accepted the relationship. They would end up having to decide it. Yeah. And so we said there was really only one outcome. And indeed, in a sense, that was the point, that by the time of the stage of the detailed grounds, the respondent only at that stage conceded that if the relationship was accepted, they were going to grant leave.
Well, you said you're going to take us through that.
Yes, I will.
I'm conscious of the time.
Yes, so...
We've interrupted a bit. Now we've come to this point that my Lord has just raised about, to some extent. That really is your case on, to some extent, isn't it?
Yes.
And in fact, you were a complete winner because you got not only reconsideration, which would normally be enough, but an outright reversal of the decision.
Exactly.
And you say, we have these points, I think, from your scales, and I don't think you need to develop them unless you want to, but the fact that you didn't get the declarations, and the fact that you didn't win on other grounds, is irrelevant because you got the key thing you wanted.
Well, they all led to that thing. No one would pursue the other remedies if you got that. I mean, if you went to a court and said, well, I still want my declaration and my quashing order, they'd tell you you're wasting, you're throwing costs away, you would be wasting. So, and that's got to be the test. Was there anything further you could have got out of the proceedings? It would have been a complete waste of time. And parties are not, that would not have been appropriate at all to keep.
Well, unless you want to say anything more about that, I think we have that point on to some extent.
You have that. So I think.
But you do want to take us to what happened between the PAP response and the ultimate concession.
Exactly, because really this is all about looking at what happened. That's the point. And then my submissions are very fast. Just on that point, that the remedies, just so you have where they are at page 180 of the bundle.
So you want an order quashing, a declaration that refusal was unlawful, a mandatory order.
That you grant the visa.
That's quite unusual, isn't it? I thought the normal remedy in judicial review is to quash the decision and have it reconsidered.
The alternative is an order that they take a new decision.
Yes.
In some cases where it's absolutely clear, and in fact, in this case, for example, there had been this may well, in fact, have been the type of case where that order could have been made because the Secretary of State had conceded that she would grant leave.
So the judge, if you'd gone to a full hearing on judicial review, you would have been asking the judge to decide whether it was a genuine and
Yes.
subsisting
Well,
relationship.
including because there were human rights grounds. So, but yes, we would have. I mean, the judge may or may not have acceded to our request. I
Yes,
accept
no, I can
this.
see that.
It's possible that they wouldn't have. But because this was also relevant to the Article 8 ground and why he needed to be with his family, his distress, what he had lost in the war, wasn't just his home, his studies and everything, it was also his wife. So he was absolutely distraught and needed to be with family. That was a critical part of his case. So,
But your point is that having got not only a new decision but leave, you've got everything that
exactly,
you wanted.
we've got everything, and the point that you've made, and was absolutely right. There's no the alternative of is a new decision in accordance with the declarations and the judgment. So if whatever finding, and that may have been what the judge would have ordered, may have said, even on any case, they may have said a mandatory order is unnecessary. I accept that, but the point is we've got everything we could possibly get out of the claim. And so...
Well, what you have not got is any concession as to whether Article 8 is engaged, the scheme is discriminatory under Article 14, all those points. But as far as your client's concerned,
yes,
he doesn't care how he gets here, he just wants to get here.
Absolutely. And again, unless you were pursuing some other remedies, unless you had a damages remedy or something, you just wouldn't, you would not pursue those points. But I accept that there has to be engagement of Article 8, and that would have been a contest on the facts, but we didn't lose on it either. And in terms of both Article 8 and 14, there would be no justification because Secretary of State was accepting he should come. So it's a completely different...
Academic, they're all academic. Right?
They're all academic, but also you don't... The justification is whether it's proportionate, whether the interest in immigration control outweighs your interest in coming back.
I'm not sure that... I mean, I think this is now an academic debate,
Yes.
but as I understood it, the Article 14 point was whether it's justificatory to have bright lines saying these schemes, these particular schemes are for Ukrainian nationals only, and your client's not a Ukrainian national, and because he's lost his wife, he's not travelling with his wife, so he can't rely on her nationality. Now, that may or may not be right, but that's what I understood the justification to be, that you have to have bright lines for these schemes introduced as an emergency measure very shortly after the invasion.
Yes, now that's right, but in this case, the acceptance was that actually he should be treated the same if his wife went missing. That was...
At which point the Article 14... But you're not going to get a declaration that the scheme is...
We weren't seeking a declaration that the scheme was...
Well,
this is,
if I may say so, this is an example of how...
Yes.
And it's not uncommon in this area at all. These interesting academic arguments can become... are interesting and will become argued over, but ultimately it's not relevant to the issue.
It is important that it isn't black and white because it's not the same. LR didn't have a Ukrainian wife. The reason once you accept that there's the wife, we then become analogous to third country nationals whose wives are there and they can come because their wives are there and they have a sibling. So, and that is effectively what the respondent in making this decision has said. We accept that in your specific circumstances and given what the rules said, you shouldn't be treated differently. That doesn't say anything about the legality of the scheme as a whole, but it says that because the justification bit of the test is both, is there a justification, and balancing the impact on you and your individual fact, is it outweighed? But here, once that decision is made, there is no proposal to keep, to not let him in.
So really, we come back to the main point. The decision obviated the need for any of these arguments.
It obviated the need, but they're also they're not arguments we would have necessarily lost, is the point.
No, but you wouldn't necessarily have won them.
We wouldn't necessarily have won them.
They just became academic.
They became academic.
I see.
But it's not decided by LR, is the point, because the facts are different.
Lengthy academic debate might rather support your argument that you simply can't get into this on cost issues.
Precisely.
It's happened in all cases.
Precisely.
Many cases have raised lots of issues, but it's decided on the basis of one issue, and that obviates the need for any consideration of the other issues.
Yes.
It doesn't mean that you were wrong to raise those issues.
Well, exactly.
In the first place, that issue is just left hanging.
Exactly.
Anyway, I'm very conscious that you said you were going to be an hour and a quarter.
Yes.
You've now got 15 minutes of that left.
Yes.
I think we've covered that point.
Yes.
I would like, for my part, to hear you on the importance of these, what happened next.
Yes, absolutely.
Between the PAP response and the ultimate concession.
Absolutely. So the respondent then at summary ground stage, and the acknowledgement of service starts at page 110 and the summary grounds at 113. I don't take you to...
It is in the supplemental bundle, yes.
Sorry, in the core bundle this is. I'm sorry. And it's document 17.
Yes.
You don't need to go through it. It's really just so you have it. But there was all grounds were defended. The date is the 21st of July 2023.
Thank you.
And the claim is resisted on the same basis.
It's resisted, but it is conceded only that grounds 1 and 2 on the immigration rules are arguable, not the concession isn't made at this stage. It's said that the interpretation of the rules are arguable, but the permission shouldn't be granted because the ground 1 on, it was grounds 2 and 3 here on the immigration rules were arguable, but ground 1 on credibility wasn't.
So the summary ground for defence, the principal point was permission should not be granted because of the issue about
The relationship, exactly.
And where precisely...
It's paragraph 3 I'm looking at the summary grounds.
Let's summarise.
Sets out the response.
Yes.
And paragraph 1 of that says it was entirely rational and lawful.
Exactly.
And that is effectively saying you shouldn't get permission on ground 1. And if you don't get permission on ground 1, ground 2 and 3 doesn't go anywhere. And you shouldn't get permission on
The rest. Exactly. But then at 107, we get permission.
That's on the papers, presumably.
On the papers, exactly.
And that's all grounds arguable.
All grounds are arguable. Paragraph 5, page 108.
What's the date of permission? 14th?
14th of September 2023.
Yeah.
So, and then you can see the next thing that happens in the supplementary bundle is the application for the extension of time, document 12, page 98.
Supplemental.
When were the detailed grounds of defence due?
I think they were due on this day, the 19th of October.
Right.
Why were they due that date? Is that
5 weeks after the grant of permission is served. In fact, the Secretary of State says
Right.
that that's when they're due in the application at page 108. Sorry, 101. I'm not seeing the tiny type.
101?
101 is the meat of the application. Document 12 in the supplementary bundle.
Yes, so this is the application to extension.
Exactly.
So
Due
detail
to be filed 19th October. Yes. I see.
on 19th of October,
and then
but an application for extension on that date.
exactly on that date. And it's because the Secretary of State is considering some of the points made in the applicant's judicial review grounds. The Secretary of State intends to issue a supplementary decision letter, and if the decision under challenge is maintained, file detailed grounds of defence within 14 days.
Yes.
Accordingly, I requested extension of 14 days.
Yeah.
And then in the justification for why the order should be granted, down in the last paragraph on this page, it says, Secretary of State is concerned that if she does not respond, the claim may be allowed on the basis that the points made in the judicial review grounds have not been answered and without the full facts. So this decision to reconsider, she's told the court it's because matters raised in the grounds, and that she's concerned that it could be allowed. And of course, it isn't uncommon in an immigration. That's what Karupen looks at. This idea that sometimes if there's a problem with the decision, the Secretary of State decides to issue a supplementary decision to, in a sense, fill the gap. Karupen then says, actually, you should normally get your costs up to that point, but if you then don't succeed in challenging that second decision, that from then on you lose them. So this isn't entirely unusual. And then the next thing that happens on the 26th.
Well, can we just pause?
Yes.
I'm sorry.
Yes.
Just so what she is saying, he or she is saying, Secretary of State is saying here, is that on the basis that the case has been so far pleaded, she's concerned that the claim would be allowed because the grounds have not been answered.
Yes, that's why. So it's hopeless to say.
Because she, yes, notwithstanding the fact you say that he or she had had
Plenty of time, exactly.
She it is at that stage.
She at that stage, exactly. She had.
Although I'm not sure what without the full facts adds to that.
Yes, I mean it
suggests maybe further inquiry.
Yes, maybe further inquiry. But when the further inquiry is done, the answer is, oh no, you're actually right, not wrong. So, and
Your point is you should have done all that earlier.
should have all happened earlier. And then you see the questions, and those are at page 107. It says, further to your correspondence dated the 22nd of June. Well, there was no correspondence on that date. That's the grounds of claim is that date. That's the date the claim was issued, as GLD then points out in later correspondence.
Are these questions exhibited to the application for an extension?
No, these come to us afterwards. So we didn't know at the time.
On 26th of October.
So they make the application, then a week later they ask the questions.
They send a whole long list of questions.
Did they get the extension they asked for?
I believe they did. I'm not suggesting that they breached an order. I don't remember the exact. Sometimes these things don't get decided fast enough, so I don't remember whether there was an order, but it was, albeit the very last minute, it wasn't made at a point where you need relief from sanctions.
So your key point here is, or I say a point you make here, maybe the key point is that all of these questions
Could have been asked.
at the PAP stage.
Yes. But also,
Is that right?
Well, I said it could have even been asked before that, because actually, when you
At the
look
latest.
at at the very latest, when you look at the actual questions, the emails to organisations helping to locate missing people, that is a reference, and you can see this from the underlying material, to the original emails I showed you that went with the application. Then you said when you were interviewed, blah, blah, blah. You said when the interview, blah, blah. These are all questions about pre-decision material, and you can also see that from the analysis. They're not questions saying you gave us this new bit of material with the PAP, and we want to ask you a question about that material you sent with the PAP.
I mean, you say many of them are pre-decision.
They're all about
all pre-decision.
They're all about
But
pre-decision.
in a sense,
in fact, on the analysis,
in a sense, your point is you don't have to say more, do you?
Yeah.
Than they were PAP decisions that should have been raised at the PAP stage at the latest, because your costs arise from the time you issue the claim.
well, exactly, but they are also all pre-decision. We then asked the GLD at page 109, please explain why these questions were not asked when our client was interviewed in February 2023.
Can you just show me where you say that?
Page 109,
9.
document 14.
Yes, paragraph
4.
Right, okay.
And we'd asked for disclosure. We said we want to see what led to this.
That's right. You asked for.
We then asked for disclosure, and you can see the point I already mentioned that he says on the page 111, tab 15. Then is the email back from GLD saying 22nd of June is when the claim was issued. we had put the wrong date in there. And then we ask for internal decision making that resulted in the new questions. And you see in the answer to question 2, GLD says, with regards to your request to the internal consideration, please find attached the relevant internal emails. And then question 4, these questions were not asked by the applicant when the applicant was interviewed, as they were not considered by the interviewing officer at the time. So they don't say because they arise from new evidence that you after the interview, because they don't. And then the disclosure, as fast as I can. If you run through the disclosure, it starts at page 113, it's document 16. There are 3 emails. There are first drafts of the questions, and those carry on for the first 2 emails. But then at page 116 is the analysis of the evidence. And that, you see, pros, some limited evidence, MRPL Life, marriage 116. Medical letters stating his current mental health situation, email to Ben Wallace and sponsor. These are all materials before any decision was made.
So this is disclosure by the Secretary of State.
That led to her asking the questions. She analyses what is really the pre-decision material, and what she says about the post-decision material, you can see at the top of 117. Both witness statements from the act's brother and current roommate not material. Information given statements told them by the act, therefore they are biased.
So, in other words, the emails disclosed in response to your request for explanations for the questions, all that material showed that the information you say was before the Secretary of State, before the PAP response.
It's a reanalysis of the material that was before her, before she even interviewed him, and things he said in the interview. All pre-decision.
Thank you.
And so things like the emails from Julia Wachakowska.
All right.
All of it.
Yes. Again, I'm conscious of the time.
Yes.
That's your submission on that.
That's
if anything
my
arises
submission on that.
You can.
It can be pointed out to you where in here there's something about the post-decision material.
Okay.
And then after that, we get there was another application for more time, and it's at this point, document 19, that the Secretary of State says, it's page 125, the meat of the application, Secretary of State compared to concede ground 2, subject to the outcome of the reconsideration, which is relevant to ground 1, and says they will.
Where are you now?
This is page 125, another extension application on the 30th of October.
Yes, that's right.
Say conceding now that they will grant leave if they accept the relationship, but they're still doing the consideration. And this also says the whole claim now turns on ground 1. The rest of it are no longer, the other grounds, 3, 4, 5, 3, 4, and 6 are no longer relevant. And then we get the decision. Finally, 166 is the explanation you should probably see the actual decision as well. 147 is the decision, that's document 23. The reasons are, having now considered all the representation and evidence you provided, including post-decision material, it's been decided to reconsider that decision. You do not meet the requirements under the Homes for Ukraine scheme. However, a decision has been taken in light of the exceptional, compelling and compassionate circumstances to grant you entry clearance for 36 months.
Yes.
That being the length of time Ukraine scheme people get. So it was the same grant of leave. that
Yes.
you would have got, and then the explanation for this is at page 166. To just point out, took a months of chasing to try and get a response, because we were saying, well, if you're disputing costs, we want disclosure of the reasons, any other reasons for this decision, and we finally get a response, and that's in this response. They say the medical evidence would not have been sufficient on its own to grant leave. This is the letter dated the 13th of March.
So which page are you on now?
166 of the supplementary bundle.
Yes.
It's document 36.
Yes.
And the reason for the grant of leave is that the Secretary of State is prepared to accept, on the evidence now presented, your client was in a subsisting relationship with his wife around the time he left Ukraine. While your client would not succeed under the rules in the specific circumstance of his case, he's prepared to exercise his discretion to grant leave outside the rules, bearing in mind the way the rules were drafted at the time of the application.
Now, can you just take us back to the earlier letter from the solicitor, which 13th of November, is it?
Yes, I believe that is it. Also the 13th. So
Is it the 13th or is it the 3rd?
14th of November, 144. The Secretary of State is prepared to accept
That's right.
on the evidence now presented your medical circumstances. Should say, I mean, my learned friend, although I think maybe at that stage someone, this letter is very similar to another letter received in a similar case.
Okay.
So
Well,
I don't know why the wrong information was given, but it's possible. It's possible that it was a cut and paste from a different case where the medical evidence was enough.
Yeah. I think
well, Mr. Hoban will have a chance to.
Yes,
to answer
I'm
that.
just.
You think so? You think that may just have been an error? Do you?
I do. It was in another case where medical evidence was the was the factor that led to a reversal,
Okay.
which both Mr. Holborn and I were involved in, so we both know about it. And so then, but of course that was a case where there was no Ukrainian wife. This was a very different case, and so given what had gone before, it's not that surprising that the actual reason here was acceptance of the relationship.
Okay. Anyway, we then get the letter. Mr.
Yes.
Hoban says a bit more about that if he wants to. Then we get to the 13th of March letter, which we've all seen.
Exactly, and
Yeah.
so then.
So is that complete our trawl through?
That has completed our trawl through the evidence. We've already looked at the decision and costs, and they're really it is short and straightforward. I don't propose to take you to it again, given the time. I've also summarised the submissions that were made to the judge.
Yes.
I do just want to point out at core bundle, page 97, what the judge was told by the respondent about the evidence. So you can see at 2H, sorry, it's not.
Yes.
Sorry, yes. In light of matters, so at 2H it said a further decision was made in light of matters raised since the decision. Then at 2J, putting the evidence at the highest, this is about the responses to interview questions. The points made were only first raised in the evidence attached to the PAP letter.
Yeah.
Well, as I've showed you, I don't accept that's accurate.
It doesn't matter
But
it doesn't matter if that's right.
Yes,
You say, because that was still the opportunity to raise the question.
exactly. But it is the problem is that the judge is also being presented though with with the sense that this new evidence was the thing, that the questions came out of evidence with the PAP, which in my submission isn't right. As I say, it doesn't even matter. I do, of course, say that. But it's also, why did she end up finding what she did? And then you see at 3, this is supposed to be a third category M. Croydon case, where settlement doesn't reflect the remedy sought.
Yes.
And because of the extensive material with the PAP and answers to further questions.
Yes.
And so that is the position
it's now
put
10 to 12.
Yes.
I'm sorry, we have interrupted quite a bit.
Absolutely.
But I think we'll have a chance to reply. We'll have to see how Mr. Holborn, how he puts it and what
Yes.
and I think that rather than hear your comments on his submissions to the judge,
Absolutely.
we'd rather hear his submissions to us now.
Absolutely.
And then you can have a reply.
I will move on and I will make my submissions extremely quickly. So I say exactly what I've said in the skeleton. Either the judge accepted it was a Category 1 case. While she says to some extent the winner, it's not clear whether that to some extent is linked to her findings on the evidence or something else. But as I've already said, if she got that wrong and she was finding we're not a Category 1 case, then it was an error. 1, because we are, and 2, because it's not clear what she actually thought. The next error is that she didn't take the correct approach to whether there was a good reason for departing from the general rule that where someone complies with the PAP and gets the remedy that they sought, there is a heavy burden of showing that the normal rule and cost should be departed from. She doesn't direct herself on that, which I accept it wasn't necessary for her necessarily to spell it out, but she had to apply it in practice, and she didn't. And in my submission, the failure to concede at pre-action stage on these facts should have been decisive. And then the second error is that there was an incorrect application of the applicable principles to find that there was some merit in the view that post-decision material was relevant and that could be a good reason for reducing costs by 25%. I say that the judge failed to take into account relevant matters in concluding that, because even if the appellant was successful, and even aside from the new decision, the nature of the new material, when it was submitted and in the context it was submitted and how it influenced the Secretary of State, is the evidence that we have about that doesn't justify the order that was made. First, we say we were successful even aside from the reversal of the decision because we got the reconsideration. Second, you can see from the internal reconsideration that occurred, it was an analysis of pre-decision material and it rejected new evidence as irrelevant. And it was on that basis that further questions were asked, and the additional material sent with the PAP doesn't justify a reduction. As I showed you, it's either not evidence that resulted in the reversal or it was evidence pointing out the flaws in the Secretary of State's approach and her decision. And the new reasons in the decision are generic. Nowhere has it ever been suggested that there was some piece of new evidence that changed the complexion of the case, that there was something you would expect if there was, the Secretary of State could take you to it and show you. It was this bit of new evidence, which we didn't have before, that made us realise he was telling the truth.
Yes.
And so in all those circumstances, there is no justification for the reduction in costs. And in addition, it was wrong in principle to proceed on the basis that relevant evidence that may be, that may have influenced the decision is necessarily a reason to reduce costs. It'd have to be more findings. Because if you have errors in the decision, the fact that there is new evidence, if it's a supplementary reason, if there are two issues, you have an unlawful decision, but you also have new evidence, which is what happened in Tesfaye, you don't get a cost reduction. There will often be new evidence by the time of a reconsideration. So if in fact the Secretary of State knows that there's a problem in the initial decision, she always has to reconsider on the basis of the up-to-date evidence. Indeed, often it's built in that you should have the opportunity to provide any up-to-date evidence. So that's not a reason without more for reducing costs. And the Secretary of State said that post-decision evidence is irrelevant to the legality of a decision. But in my submission, that's wrong in this case, because the post-decision evidence was explaining why the decision was unlawful. And as I've already said, if there was a critical piece of evidence, she should have been able to show us what it was. But anyway,
Yes.
she had the opportunity to reconsider pre-issue. So those are my submissions. I was going to make some points on the respondent's case, but I won't for now.
Well, I think
will
that,
save
that's
them.
something you should do on reply if necessary.
Yes, exactly.
Anything else? Thank you very much. Now, Mr. Hogan.
My lords, if I may start by addressing what this claim was about. And it had three elements, and I've summarised them at paragraph 11 of my skeleton, but I say three, although there were 6 grounds, because they really fall into 3 pots. The first pot relates to the question of whether or not there was a subsisting relationship. Now that was a question of fact, and under normal principles of judicial review, the Secretary of State was only obliged to consider matters in front of her at the relevant time, and the normal remedy might have been a quashing order. The second element of this, which is grounds 2 and 3, was a challenge to interpretations of the rules. Now this is the challenge that had been foreshadowed in the first judicial review, which was settled prior to issue. And the issue there was that the Secretary of State's view, it appeared since the start of the Ukraine schemes, had been that when you were a foreign national applying as an immediate family member of a Ukrainian national, you would apply together, or that foreign national would apply after the Ukrainian national. In this case, unusually, you had the foreign national applying on their own. And as was ultimately conceded in the grounds, there was an ambiguity in the rules.
As ultimately conceded where?
In the summary grounds of defence, I believe, or certainly the detailed grounds of defence when we settled.
Well, it might be helpful to know precisely which.
I think, let me just
Well,
but we conceded permission, obviously, on grounds 2 and 3 in the summary grounds of defence. So it was conceded, it was arguable.
It was conceded in the second application.
The second application for an extension. I think it was yes. It was expressed in the way I just expressed to you now.
So,
in the second application for an extension.
as ultimately conceded in the second application for an extension, there was an ambiguity.
There was an ambiguity. Now, it didn't necessarily mean we accepted that. We didn't accept there was any illegality. But by
Ambiguity in the drafting, in the way the rules was drafted. Yes.
But as it happens, by that point, the rules had been amended to make the position clear. That obviously post-dated the decisions under challenge in this case, though.
Yeah.
The third basket was the challenge on Article 8 and Article 14 grounds, and the substance of the argument was that there was a breach of Article 8 and Article 14, and the contention was that the tribunal should find there was such a breach, and it followed that leave must be granted. And this led to the arguments for a mandatory order. So that's the context in which this claim is proceeding. And that matters because in relation to that third basket of claims, it will be noted that on the Article 14 grounds at least, the tribunal has now considered that question in LR, and found that the bright line rule was justified.
That's a decision of the Upper Tribunal.
That was a decision of the Upper Tribunal, yes. It came before this court on appeal, and that appeal became academic on halfway through.
So there's no decision of this court.
There's no decision in this.
But the Upper Tribunal has considered 3 and concluded contrary to the assertion by the appellant.
Contrary to the assertion by the appellant in respect of Article 14. The Article 14 arguments were the same. The Article 8 arguments were similar. Obviously, they are fact specific.
How does the fact that the Upper Tribunal has subsequently made that decision impinge upon our decision? Or how did it impinge upon the Upper Tribunal Judge's cross decision in this case?
In relation to it impinges, we'll come to it in 2 respects. One, it is it's mainly relevant to our grounds on the respondent's notice. One, even at the time, it was clear that significant grounds pursued by the appellant had not been successful. The tribunal didn't know they would subsequently be unsuccessful, but they did not know it would be successful. 2, if you were to take a different view, ultimately, it would be unreal if you didn't take into account the fact that there is now an Upper Tribunal judgment that shows that ground would have been unsuccessful, at least at first instance. So, in my submission, that will largely becomes a relevant factor when if we were to step into the world of.
So the fact that the applicant here sought to take a legal point which has subsequently been rejected in another case,
yes,
is a factor which the Upper Tribunal judge in this case was entitled to take into account when considering costs, notwithstanding the fact that you conceded that the point was ambiguous.
No, that's the second. That's the second.
Okay.
That's the third.
Ignore that last point. It was the Upper Tribunal judge was entitled to take it into account.
Yeah, yes. The Upper Tribunal judge was, but it also explains the reason I raise it now up front. Although in fact that last point essentially goes to the respondent's notice, is because it explains how this case unfolded. There were 3 important areas. This wasn't a case just about whether or not this man had a subsisting relationship with his wife, which was a straightforward issue of fact. And had that been the issue, the only issue, everything would have been a lot more straightforward. That's not the case that was brought. The case was brought on all 3 of these separate strands.
Yes. Ultimately, however, didn't the Secretary of State concede that the matter turned on the question of the relationship?
Ultimately, having conceded point 1, and ultimately it was accepted that substantively leave would turn on that issue in this case. In light of the change of the immigration rules, the Secretary of State took the position that she would exercise discretion and determine the case as if the claimant was right on interpretation of the immigration rules. So there was effectively a concession of at least outcome in respect of grounds 2 and 3.
Your argument about the Article 14 point, it does not form the basis for the decision of the judge below, does it?
No, it doesn't expressly, albeit there is reference to our submissions which did raise this very point.
She refers to your submissions, but then says there's merit in the view that the post-decision information
she's
was
looking
relevant.
She's looking at both aspects. She's looking at the post-decision information. That's the core of her reasons. But she refers back to our submissions in their entirety, and those submissions were very clear on the point that the relief sought was not just in respect of quashing orders and related to this wider point on Article 14, our written submissions. So we say she has taken that into account, although I accept it's not the key matter in her mind because she doesn't go through that in detail. What she does is analyse this, should we say, contested point on the facts, which is whether or not the evidence made a difference. Obviously, it wasn't contested, particularly that the issues of Article 14 hadn't ultimately been determined. So, as I say, I raised that at the outset because that explains quite a lot about how this case actually develops. This is not a case just about whether or not this individual had a subsisting relationship with his wife. The letter comes in the pre-action letter comes in on the 6th of April. Sorry, the application was refused on the 6th of April 2025. And you've seen already the reason, so I won't take you to that again. The pre-action protocol letter then comes, raising all the grounds that were ultimately pleaded, and with a very lengthy witness statement, which again you've been taken to. So that's ostensibly new evidence. And the normal position in the world of, if this was just about, is there a subsisting relationship, would have been a straightforward answer of, no, we don't, that's new evidence, and we say the decision at the time was lawful. And that's the end of it. And you might say to the claimant, you can make a further application. But of course, in reality, what the claimant is doing is raising two other significant points of principle. One of which is as to interpretation of the rules, which then changed, I think, in August 2023. And as to Article 14. And as my learned friend noted, there were a couple of other cases around the same time relating to that point. And so there are points of principle. So it's unsurprising you go from 70, the pre-action protocol letter cannot be responded to in the space of 2 weeks. It is raising significant points of principle beyond this factual dispute. When the grounds...
Did those points of principle not arise in either of the earlier JRs?
They hadn't arisen in the second point of principle arose in the first JR, and the Article 814 it did rise in the it wasn't responded to. It wasn't the first JR hadn't got off the ground, shall we say, because there was consideration of reconsideration pre-action.
So they did arise, but it hadn't got off the ground.
Hadn't gone off, yes.
Settled after permission.
Settled after permission.
I'm sorry?
Settled after permissions. Oh, I apologise. So
it's not the first time Secretary of State was on notice.
No, it's not the first of the points of principle. No, it's not the first time the Secretary of State's on notice of the points of principle. But it remains the case at this stage, the Secretary of State is considering two significant points of principle, which are of significance to other cases. And a pre-action protocol letter is sent, which you've taken to, and you'll note that the way the pre-action protocol letter, quickly take you to a couple of examples, approaches this challenge is to look at the pre-decision evidence. What it doesn't do is say the post-decision evidence doesn't make any difference at all, and that's the end of it. That's not.
Sorry, when you say the letter, you mean the response?
The pre-action protocol response. So if I quickly take you to the pre-action protocol response again, which is at...
So may I make a note of that submission? The pre-action protocol response refers to the pre-decision material,
yes,
not to the PAP letter
and
new evidence.
No, it doesn't say. It doesn't take the position that the Secretary of State has considered this material and rejected the case in any event.
Okay, well, do you want to show us that?
Yes. 84.
In which bundle?
In the supplementary bundle.
Thank you.
And the wording of it is backward looking in my submission. So ground 1 is dealt with at 86 to 87. Well, that relates to as actually the ground 2. So the key ground here we're looking at is in fact ground 1.
Yes. Well, what the Secretary says is that she's reviewed her decision in the light of representations made in the letter.
Well, indeed, she's reviewed her decision. It doesn't mean she's considered all the new evidence.
Does it
In
not?
relation to the
why
submissions made.
Why doesn't it? Why doesn't it mean that she's considered the evidence given with the letter?
Well, you look to ground 3, the assessment of credibility. That's where that's what the ground is responded to, and the submissions made in the PAP letter are summarised at paragraphs XV III onwards, and then at 22 XXII, SSD maintains a position as set out in the refusal decision, and then it analyses the statements by reference to the pre-decision evidence, and then back to paragraph 26 looks at as detailed in the decision of 6th of April.
Right, so
it's
I'm
an
looking at
analysis.
page 90, is that in the right place?
Yes, page 90 to 91. That's in my submissions, an analysis of the strength of the 6th of April decision and the pre-decision evidence.
Right.
I say
so,
this is
forgive me.
sorry, yeah.
Where the response says Roman 18, you allege, and then Roman 19, you further state, 20, you assert that, 21, you add. Is that a reference to the PAP
letter?
PAP letter.
Yes.
So here, the Secretary of State is responding in detail to assertions in the PAP letter,
Yes.
right? And your submission is that that was not with having taken into account the evidence filed with the letter.
It's not a fresh decision. It doesn't purport to be a fresh decision, as though the claimant has made a fresh application.
No, it starts by saying at paragraph 6 that the Secretary of State has reviewed her decision in light of the representations raised in the PAP letter, and is satisfied that the decisions are in accordance with the law.
So it's reviewed in light of the representations in the PAP letter. It's not saying, well, we've taken into account everything you've sent, we've made a fresh decision, and this is a fresh refusal, as if you'd had made a fresh application, and that would be the normal position for such a claim. If you were to send further material with the normal response is, well, you can make a further application in respect of that further material.
I'm sorry, I'm sure it's me, Mr. Hill, but I'm not quite following this. What does reviewed her decision mean?
Or reviewed the decision letter and the representations made in the PAP letter. What it doesn't mean is she's taken a new decision on the basis of the new information.
It does mean, doesn't it, that even having reviewed what's contained in the PAP letter, she's satisfied her decision was correct.
She's satisfied her decision was lawful. But that's a slightly different question, because the starting point for this kind of decision is that what matters is what was in front of the decision maker, not information post-dating the decision. You get it. You do get it all the time that people will put in further information post-decision. The Secretary of State isn't required to then go about and make a fresh decision based upon a PAP letter, absent where there isn't a requirement for an application.
What is she doing when she's reviewing her decision?
Well, she's reviewing what was said in the 6th of April decision, and she's reviewing the complaints the claimant makes about how that decision was made. What she's not doing is a reassessment of credibility based upon the new evidence.
But she does say at Little Roman 22, she maintains her position. It is not accepted that your client's relationship with his wife is subsisting.
Yes.
You say that's not a decision taking into account all the material in the PAP letter, but only the material in the PAP letter which goes to the material that was before the decision maker.
Well, essentially, it's not a reassessment of what the Secretary of State hasn't done, for example, is reopen the question of asking questions of the claimant or done anything of that nature. It's just said that the position is you haven't got much of it. Now, what is missing, which then goes in the summary grounds of defence, is the flag that if you want a full reconsideration of credibility, you can make a further application. I accept that's not clearly put in the PAP letter.
Sorry, which sentence is not clear?
What is not clearly put in the PAP letter generally is reminding the claimant that if they want a full reassessment of credibility in light of new evidence, they can make a new application. That, I accept, is not included. It is then included in the summary grounds of defence.
Just a moment, please. Can I just take you back then, to what is said in the paragraphs above that, paragraph Roman 22?
Yes.
In 20, you say, the Secretary of State says, you further assert the Secretary has unlawfully failed to consider your client's explanations of the circumstances regarding his wife's disappearance as set out in a witness statement dated the 11th of May 2023.
Yes.
So that is a witness statement. I'm not quite sure which one that is, but
that's the witness statement that's provided with the PAP letter, I believe.
Yes, I think that's possibly a slightly wrong date. That's all right, but anyway. So doesn't that suggest that that the Secretary of State was purporting to have reviewed her decision in the light of that evidence?
Well, no, but then if you look down at the reasons, what's said is the Secretary of State maintains her position as set out in the refusal. The statements provided by your client previously have been wholly inconsistent. And then by reference to material prior to that May statement. So in my submission, what the letter is doing here is saying, okay, you've raised the statement, but actually, look, we at the time of the 6th of April decision, this is what you had, and it was all inconsistent.
Yeah.
It's foreshadowing, of course, that that the Secretary of State's immediate view is that the May statement doesn't add much, but that's not what it's analysing.
Mr. Hoban, forgive me for being blunt, but I find it difficult accepting that analysis. What I read that as saying, at the moment, subject to hearing, of course, what you say, is that notwithstanding what your client asserts in the witness statement of the 11th of May, the Secretary of State adheres to her view because the statements previously provided were wholly inconsistent. I mean, I may be reading a few words into that, but I read that as, at the moment, as suggesting, as indicating that the Secretary of State wasn't persuaded by the new material because of the inconsistencies in the previous statement, because they were, quote, wholly inconsistent.
I can see the point that you're making, and that is also entirely correct. But ultimately, the analysis here, the reason for rejecting it at this point, is to say, well, look, there are all these inconsistencies. This is what the 6th of April decision analysed. And that on the pre-decision evidence. You're
quite right, of course, that the question was whether the decision was lawful, not whether it was correct. But actually, at Roman numeral 28, it says the Secretary of State is therefore satisfied that the decision maker was correct to conclude that the client's relationship is not subsisting. And that's having analysed both what was before and what came with the pre-action protocol.
There's mention of the pre-action protocol. There's no actual analysis of what's in that statement in my submission. It refers back to previous discrepancies. But even if that was so, it doesn't change the fundamental position that what is being done here is a response to a challenge to the 6th of April decision. So even if the Secretary of State is, as she did subsequently, as we'll come to in the summary grounds of defence, not particularly convinced by that evidence. What the claimant hasn't done in the PAP letter is make a further application, which they could do for free. If there was no application fee for this application. And what the Secretary of State hasn't done then is generate a new decision. Moving forward to the summary grounds of defence. This is addressed at paragraph 27, and you'll see the way the reason I put it the way I have now, because this is then foreshadowed in that it's followed up in the summary grounds of defence. 27.
Paragraph 27.
Paragraph 27 is page 122 of the core bundle.
Thank you.
SSHD further highlights that much of the argument under this ground is generally attempts to clarify the applicant's previous evidence. To that extent, it was not material before SSHD at the time of the decision. Whilst SSHD's clear indication given now is that it's very unlikely to alter the outcome, although SSHD does not fetter her discretion, it remains open to the applicant to make a further application relying upon this evidence and to do so without charge. So it's highlighting the point I've made. I accept that the indications are that the Secretary of State was not particularly convinced at that time.
Doesn't that suggest that the Secretary of State had considered?
Well, as you say, it's the Secretary of State has clearly spotted there's a witness statement attached, and as my lady referred to, there is mention of it. But what's not been done is a full analysis of the information and a fresh decision. What there is a review for the purposes of considering, is this 6th of April decision unlawful? That's what the Secretary of State has to do. The Secretary of State has to read the witness statement, because otherwise there's a risk that points put that are really submission will be missed, even if she's entitled to take a more robust approach to new evidence.
The applicant didn't have to make a further claim, did he, for the Secretary of State to change her decision?
No, what we say...
Indeed, she ultimately did change her decision.
She did.
Without a further application.
She did.
On the basis, to satisfy the relationship was subsisting.
Ultimately, on the basis of the decision of the Secretary of State was to waive any requirement to make a further application and to make a fresh decision on the basis of the new material and ask further questions.
Wasn't
which
the
was not
Secretary
on the state.
Given that the Secretary of State was supplied with this further evidence, wasn't she obliged to take it into account as part of her conduct when responding to the PAP letter?
Well, in what sense? She wasn't obliged to retake the decision as she did subsequently.
Wasn't she obliged to read the evidence that was given to her?
Yes, no, I accept the
To
knowledge.
decide whether when reviewing the decision.
No, the Secretary of State is not required, in general terms, just because someone puts in further evidence following a decision, to reconsider whether that decision is correct. She's required to consider whether that decision was lawful.
But she actually said it was correct.
She did say it was correct. I agree.
She could have said, I'm not taking account of new evidence set out in the witness statement because that wasn't part of the original decision.
I accept that, but our submission is that what that really is, because it doesn't say that this is a fresh decision, it's a strong indication, as I put in the summary grounds of defence. The Secretary of State at that point thinks this evidence isn't much.
Is the decision that she is the decision she is the decision that she ultimately made a fresh decision or not?
The decision she ultimately made is a fresh decision. Yes.
Without a further application being made.
Yes. So the requirement for a further application is waived subsequently. That's what the Secretary of State does. She could have maintained her position, and the reason she does that is there are a couple of reasons. First, obviously, in terms of the point of principle on grounds 2 and 3, that's rather fallen away. You can see that. Second, the point my learned friend has made, rightly flagged, that when asking for extensions of time, the Secretary of State was concerned that the claimant's challenge was that not only was there unlawful decision making, on the 6th of April. But the court now should substantively consider the Article 8 and Article 14 positions and reach its own conclusions on that.
Sorry, just say that again.
The court should substantively...
At what point was this her case?
This was the applicant's case, was part of the applicant's case on the article, following from the Article 8 and 14 grounds, was that the tribunal should reach substantive findings on Article 8 and Article 14, which was one of the bases for the mandatory order. I'm not saying she wouldn't have argued it for another basis, I'm not sure, but certainly would have appeared difficult to argue it on any other basis. And the Secretary of State, so in pursuing that argument, the applicant was relying upon substantive new material and the Secretary of State was concerned that the tribunal might go ahead and start making findings upon that substantive new material without the Secretary of State having reached her own determination as, for example, the balance of Article 8 and Article 14 outside the rules.
Should we just look at the letter in which she makes that point? It's the extension.
Extension application.
Can we just remind ourselves of the wording of that, please? Where is that? I forgot.
That is at supplementary bundle.
Is this the first extension application or the second? I think it's possibly the second. 122, tab 19, or is it the first? This is tab 12. I think.
Thank you.
I think it's the first.
Yeah,
12.
Yeah, so it's the
Page 101, isn't it?
yes, page 101.
She's concerned that if she does not respond, the claim may be allowed on the basis that the points have not been answered without the full facts.
Yes. The Secretary of State hasn't undertaken a full consideration of the full facts and, of course, the submissions made in the grounds.
With that.
And this is in the context where the claimant is contending that the Upper Tribunal should follow a process of considering substantively Article 8 and Article 14 rights. And the Secretary of State hasn't actually reached a reasoned conclusion on everything that's now before the tribunal. And so in another world, this case might have led to a supplementary decision saying no, and the claim would have proceeded to final hearing, but with the benefit of the Secretary of State's considered view upon the further material, as if a further application had been made without a, although it wasn't.
What were the full facts that were relevant to the rounds 4, 5, and the points 2 and 3 on your analysis?
The full facts, you mean grounds 2 and 3 on the...
No, the way you put it,
Your basket.
My
Your
basket.
two
My
and
basket.
three.
basket. That's right.
Basket.
Second basket and third basket.
Basket 2 was not significantly affected. That's a simple point of principle as to what the immigration rules meant, so that doesn't matter.
And what were the facts relevant to basket 3?
The facts relevant to basket 3 would be what at this stage, of course, the claimant had provided some additional medical evidence, albeit that it's accepted there's that wasn't ultimately the reason for the decision. That all went to the Article 8 balancing exercise. And of course, in the world where the Secretary of State if the Secretary of State had determined after that point that she was going to defend her policy position in this claim on the second basket, that might have been very significant. Because there was another prospect at this point, that the Secretary of State might accept on reconsideration and on credibility interview that there was a subsisting relationship, but still fight the policy point. Ultimately, that wasn't the position. And in that scenario, it would have been necessary for the court to go on, the tribunal to go on and consider the Article 8 balancing exercise, including on the basis that there was a subsisting relationship. So that's why I say when we started here, that's why the way this claim pursued really matters, because it's about more than one thing, and it explains why it's not straightforward, and that response takes time and comes after the claim. I'll come back to some alternative positions on the PAT response. We then get to consideration of the new evidence. Now, in my submission, there is some significant new evidence provided. Sorry, there's one further point which I've missed out, which I will go chronologically. What is the claimant seeking, the applicant seeking? Throughout, the applicant is seeking declarations of breaches of Article 8 and 14. I think you have that point. Obviously, those are likely to fall away, likely but not certain to fall away, when someone is granted leave. Couldn't say that the applicant might not still want declarations as to breaches of human rights.
Well, your point was that the claim would be academic.
The claim would be academic, but equally, you don't know, for example, whether or not the claimant wishes to pursue an academic claim on zoo life principles because there's other matters, there's other claims in the wings, and/or wishes to rely upon those declarations for some other reason.
Sorry, you referred to zoo-like?
The zoo life principles. Sorry, the zoo life principles on academic claims proceeding.
Right.
I say this solid.
It's shorthand, which you're familiar with, and I'm not.
Sorry, my apologies.
But it's the basis. The court can be invited to decide an academic case if it has consequences more generally. More generally,
yes, and there are two standard principles as to when that might be appropriate. Discussed in the case of zoo life, looking back to the case of Salem. So these don't automatically fall away, these declarations, just because the claimant's granted leave. The declarations might be sought in any event, either by the claimant on his own grounds, or for his own benefit, or for the benefit of the wider cohort, which was there were other claims in the wings. When the new evidence comes in, though, my suspicion is there is significant new evidence.
When you say when the evidence comes in, just
with the PAT pre-action protocol letter, the 11th of May statement and the exhibits. That does contain some notable additional material. I think, as already identified, it contains additional explanation of what was going on between the person completing the forms, and the applicant.
Do you want to show us what you say in that?
In terms of the explanation?
Well, what you say was the new information.
Yes.
Significant new information.
So, if we look at 284 of the core bundle, you'll see the interview transcript. and you'll go to question 67.
Yes, which I think I looked at earlier.
4.
67, level of English.
Given your level of English, did you not realise at the time that a misunderstanding may have occurred? Did you not ask Abdul to read back? The answer is no. And of course, when it comes to the supplementary, the witness statement, if we go to supplementary bundle, page 41. This is just one example of where the claimant then provides additional explanation.
Just before we look at that, I'm afraid I didn't get the reference for the interview transcripted.
It's page, question 67, and it's page 294 of the core bundle.
294, thank you.
So you will see some extra explanation there. I say as an aside, this is in the course of a passage where the claimant is going through the refusal.
Which paragraph in page 41?
Sorry, no, it's paragraph 40. Paragraph 44 is the paragraph responding to question 67. You then also get, I note, and it's not addressed in any of the evidence previously, AB5, which you were taken to, which is the telegram message. That's not mentioned by the applicant in the interview or previously.
Sorry, where is that in the supplementary bundle?
AB5, you were taken to before, is at 66.
Yes.
That's new information.
You mean the
This is a telegram group.
the foreigners in Ukraine?
Yes.
Um,
Telegram.
Attention, please, missing person.
Yes.
When you say, okay, that's new information.
That's new information. It's of course notable because it's 2022 information.
Screenshot at AB5. Yeah, which
no.
we've already looked at. Yes.
There are then additional information. The other exhibits on.
Yeah, there's the next. There's the ones on AB6, which are along the shorter answers. I looked at those anyway.
Yes.
Okay, and AB6.
AB6, yes.
Okay, right.
And in general, what you get is an explanation, as I say, throughout the statement, an explanation of the discrepancies raised.
Okay.
And that's at paragraphs. Paragraphs 28 through to
Onwards. I mean, in the supplementary bundle, page 89 in the statement.
yes,
Okay.
no, through to page 46 of the supplementary bundle.
Okay, fine.
It-
So that's
the bulk of the statement is explanation of why
Okay.
the Secretary of State is,
all right.
is wrong. And it's
So so this is significant information. You've described it as
yes.
new significant information.
Significant evidence, at least. Yes.
Evidence.
Yes. Some-
New significant evidence filed with the PAP letter.
Yes. And that in turn governs at least some of the questions that are then put to the applicant. And we went to them before. We'll quickly go back to them at page one.
For my part, I think, look out to the time, I think I'm prepared to accept that as a proposition.
Yes, some of the questions.
The significant new evidence is the detail about the language difficulties.
Yes.
And the evidence of looking for his wife.
Yes, there's additional evidence of looking for his
And the general explanation of
And general
paragraphs 82 onwards, 28 onwards.
Yes.
And that formed the basis of some of the questions.
Some of the questions. I accept it's not all the questions. This is, of course, this is, as I think we've acknowledged, a different interviewer, caseworker coming at the case afresh.
All right.
So,
but the central point, I think, from my point, you've got to confront is this, and it's mentioned in the earlier authorities. The whole point of the pre-action protocol is to flush out these issues before the claim is issued. That gives you the opportunity to consider points made in the PAP letter, which at the moment I think includes the evidence. Let me just be frank about that.
Yes.
And that's the whole point of the protocol, to head off the need for this expensive litigation, because of and that's what's said by the Court of Appeal in Croydon and in TEFSE. So,
well, yes, but the thing is, none of this would have happened. The Secretary of State could have taken the position that you just make a new application, as we said in our summary grounds of defence. That's the end of it. Make a new application, unless the claimant was raising the Article 8 and Article 14 grounds, which they have not succeeded on. That's the only reason why the Secretary of State has to then grapple with this.
Would it have been open for the Secretary of State, having considered the new material at the pre-action protocol stage, to have made exactly the same offer, or put the same case forward as she did some months later? Namely, if we grant you leave, that will make the rest of the claim academic, so it would all then fall away, wouldn't it?
Well, yes.
Why couldn't that have been done? Why couldn't this all have been done at the pre-action protocol stage? That's really, seems to me, the case you've got to meet.
One of the answers to that, as I identified earlier, is that the change in the immigration rules, making the position clearer and making these claims, the position on whether the claimant was right on the immigration rules, become academic, changed in August.
Yes, but that wouldn't have. What impact does that have on what I've just put to you? I mean, if you'd said, okay, we accept on the basis of this evidence that there was a subsisting relationship, therefore the rest of the claim is academic, wouldn't the whole case have fallen away at that point?
No, the whole case wouldn't have fallen away at that point, because, of course, when the claim was issued, the immigration rules were still as they were at the time of the decision, and the claimant was, the Secretary of State's position was that you didn't apply with a family member, and that's the end of that. And that remains.
But there was the ambiguity, which you subsequently.
There was an ambiguity, and so what ultimately the Secretary of State decided is, well, and by that point there were other claims deciding the point of principle in Article 8 and Article 14.
Yeah.
We're not going to fight on basket 2, which I accept is a concession for which in the normal circumstances we end up paying the costs for. But that is why we get to the position that we get to at the end.
So which is the only real question is the relationship genuine and subsisting?
Exactly. So that's ultimately the reasons why we end up where we are.
Just so I've understood this, you're saying, are you, that even if you'd made the concession about the relationship at the time of the PAP response, that wouldn't have got the applicant home because of the what you subsequently conceded was to be the ambiguity in the rules?
The ambiguity, exactly. The ambiguity was there to be contested, but the rules were then amended to amend the ambiguity, and ultimately
you decided that the rules having been amended,
yes,
the applicant should get the benefit of the doubt on the ambiguity,
yes,
having been established the regime.
Were the rules amended in the applicant's favour? No, they were amended. So it was obvious that even if the relationship was subsisting, a fresh application wouldn't succeed under the rules, and that's why leave was eventually granted outside the rules.
Yes.
But then why does changing the rules to make it more difficult for someone in the applicant's position to succeed, why does that lead to the concession? I haven't understood that.
Well, it leads to the concession in objective terms because there is no, there are almost no other cases to deal with. There is no wider point of principle, and it's decided that there's no need to fight that particular
And effectively,
point.
it's accepted there was a concession, there was an ambiguity, it needed to be corrected. So for these limited group of claimants, they should have the benefit of the doubt.
Well, indeed.
Doesn't that mean he won on that point?
I don't shy away from the fact the claimant ultimately won on that point.
But does that mean?
Reference?
Excuse my ignorance.
Yes, no.
Before you were telling us that what normally happens in cases like this is if fresh evidence comes in, you say, well, you can make a fresh application. But if he'd made a fresh application, it would have been under the new rules, and it wouldn't have succeeded.
No, not at the time of the PAP response. The new rules hadn't come in. The new rules hadn't come in. So not at the time of the PAP letter when they provide the new information. So not at that point. They could have absolutely made, under exactly the same rules, he could have made the same application. It's only later that it becomes an issue, which, as I say, another reason why ultimately insisting on a new application becomes ever more complex. But that is the context in why this claim develops as it is.
I can see what the Secretary of State's thinking was, which you've explained in a way which I hadn't quite got my head around before. But can I put this to you? Whatever the reasons, the position the Secretary of State ultimately ended up in was the only question is, was it genuine and subsisting? I'm going to look at that again. I looked at it again. I'm satisfied that it was. And he gets his leave.
Well, yes, that is correct. But of course, it's in light of, firstly, at the PAP stage, the applicant has no right to a fresh decision, and the Secretary of State doesn't say, "I'm taking a fresh decision." Even accepting, let's assume for a moment the Secretary of State has fully considered every aspect of the evidence in full and has undertaken a full credibility reassessment, which, as I suggest from the summary grounds, is not quite the Secretary of State's position. Even if that was so, what that letter PAP response does not do is say, here we are taking a fresh decision. What it is saying is this evidence would make no difference, even if it had been in front of the decision maker. That's the high point of what that letter is saying. And so what the concession that comes later is, in fact, well, we are going to waive an application requirement. That's what the letter says. That's what ultimately the concession is. And that ultimately does lead to a fresh decision. So that's why we submit that the judge has done here. Looking going back to the grounds, and I will address them briefly because you will ultimately have the points very quickly. The judge here has considered what happened in this case.
Are you taking us back to the judge's reasons now?
Well, I'm taking back to the judge's reasons, which you've seen before, and my skeleton argument.
Yes.
I will just rattle.
Well, it's very helpful. So it would be helpful if you could just flesh out, in the light of your explanation, how you put the case. Yeah.
Yes. So what the judge has done at
Tab 11.
Is under paragraph 2 referred to the costs. Paragraph 1 referred to the submissions. Paragraph 2 referred to the position.
Yes.
And paragraph 3 has then considered all the reasons why there was this change of position.
Yes. But she does say, her reason is, that there is some merit in the respondent's view that post-decision information was relevant to the decision to grant entry clearance.
Yes.
So she focuses on the whole subsistent relationship issue, doesn't she?
Well, indeed, that is her focus, but that's correct. Even on the position put by your lordship, we're referring to post-decision evidence here. What she's not saying is it's post-PAP evidence.
Or shouldn't she have said that?
Well, in my submission,
and that's it.
In the
in
context,
simplistic terms, Miss Nor's case. She should.
Well, in my submission, I think Miss Nor's case goes.
It does go further. Miss Nor says she was wrong about that.
But what
she wasn't wrong about that. Her fallback position, it wasn't post-PAP decision.
But what she's done there is take into account that post-decision evidence was relevant to the grant of entry clearance, and then still awarded the claimant 75% of the costs. Now, if it was the case that the post-decision evidence was all that mattered and the PAP process was entirely irrelevant, and none of the other factors were relevant, it'd be surprising that the applicant got any of their costs.
Yeah.
So what she says is, having read the submissions carefully and considered the basis upon which the respondent changed her position, it seems to me there was. So she's considered the timeline that we put essentially the timeline of this concession in our submissions.
And she says there are matters going on, matters properly raised by the respondent which reduce the applicant's time for costs. You're saying that we should read that as meaning all the points you've taken to us.
All the points in the respondent's notice, which we've included for the avoidance of doubt. So we say what she's done is correctly identify, firstly, that this is essentially a partial success case, albeit maybe majority success, because the declarations haven't been obtained. So that's the first point. And then she's analysed the basis upon which the change of position arose, rightly referred to post-decision evidence, consider the other factors we raised in our submissions, and then come to her conclusion, which is to award the applicant the majority of his costs. So, in my submission, what the first ground is really doing, one, it's wrong to suggest this is a Category 1 case. But two, there are sufficient reasons. This is where the reasons points come in. There's reliance upon a lack of reasons in the side. Just before the hearing, your associate identified...
No, that was a misunderstanding. Don't make any submission on the basis of that. There was a misunderstanding between us and one of the clerks.
I have copies of English if required, but it's...
We're English is authorities you appreciate well known to us.
I thought it might be. I have to say I hadn't noticed it wasn't in the respondents bundle, but in the authorities bundle. But
if we need to refer to English, we can get hold of it quickly.
Yes, thank you. You have to review the contextual material as identified in English, and the contextual material in particular is the submissions. So, my submission, when you review the judgment, you also have to look at what was in front of the judge, which he expressly refers to. And what she's done is balance all those reasons and come to in some degrees, is always somewhat of a finger in the air exercise. Who's won? Who's lost? What are the reasons for that? And in my submission, whatever it may be that you consider the applicant was hard done by. But in my submission, that was
not for this court to interfere is your final.
Not for this court to interfere. On ground 2, that obviously is repeated.
Yes.
The ground, which is an error of the post-decision evidence, the judge has correctly identified that there are bits of new material that come post-decision. And she's taken that into account in her overall cost decision. If it's not a case where she said this was crucial and there was no way, it's not a case where the judge has said, well, of course, it was all post-decision. Otherwise, if that had been the case, we might have got a better result on costs from the Secretary of State's point of view. And then we get to failure to balance the factors fairly. In my submission, it's an invitation to remake the decision.
Yes, it doesn't add anything.
Doesn't add anything, no. The respondent's notice is, in my submission, important. You already, I think, have the substance of the submission, but there were all the other matters that we put out in our original submissions.
The cost those are the cost submissions, which you say was the context.
Yes, indeed.
even though it's not referred to.
Yes.
That's fleshing out that argument.
Yes, but crucially, of course, it's also an answer to the if you were against me on this being a Croydon Category 2 case and you said it was a Category 1 case, we've got reasons in there to depart from the normal rule. And the particular reason is, of course, these Article 8 and Article 14 arguments, those grounds, they were very significant. As you will have seen from the case of LR, they required detailed and difficult argument. It took a significant amount of work, and the claimant did not succeed in them. I understand at the time the decision was made, it wasn't knowing what would happen.
But the judge really doesn't refer to that argument anyway, just looking at the summary of the respondent's arguments. She says that that's on the ground that the respondent's decision to grant entry clearance was made only after further evidence and other matters which led to her changing her position.
So yes, at that point she does. She cross-refers to our submissions at the end of that paragraph, saying there are matters properly raised by the respondent which reduce the applicant's entitlement to costs. And she's obviously referred to having read our submissions elsewhere. So in my submission, she's taken that into account. But in terms of the respondent's notice point, it doesn't matter, because the respondent's notice is really to say, well, look, even if the judge made an error here, you've got to come back at this afresh. And the position is that the applicant raised a significant argument, which they didn't have to raise. They did not have to pursue those grounds on Article 8 and Article 14. And they haven't succeeded them. And you now, as the court, are in a far better position than the judge to know how the merits of those would have gone, because there is an upper tribunal judgment.
Can I raise a technical point, which is your respondent's notice is to uphold the decision of a judge on alternative grounds.
Yes.
But what you're actually asking us to do is, if we set aside the decision as being flawed, you want us to go further than the judge did and reduce the cost to 50%.
We're not asking. We're not
pursuing that.
We would have had to raise a cross appeal.
That's what I was going to ask.
We might have. Certainly something we considered, but ultimately
it was suggested somewhere. I saw it somewhere, but it's not pursued.
It's not pursued.
Thank you.
Thank you. No. I think it was suggested in our original submissions. That's what we were after. We said nothing or 50%.
Yes.
Yes.
But no, we've not pursued that on this appeal. The final points to make. If you were against me on upholding the judge's decision for different reasons, I do flag that if we're going down the route of, well, you should have responded in the PAP response, there is a timing point as to when the applicant's costs should run for, in terms of orders that would replace this order. It's obviously not a point I've raised, but it's obviously become prominent in the course of arguing this hearing that the point made by your lordships is that maybe the Secretary of State should have done something different in the PAP response. Well, that suggests in my submission that costs should only run from the PAC response. If that was the reason for you allowing this appeal.
Thank you.
Those are my submissions.
Thank you very much. Yes, now, Ms. Law, we'd like you to reply. Assuming you're not going to be very long, we'd like you to reply now.
I'm very grateful, my lord. I will be as fast as possible. The first point I want to make is about this new application point. We could have obviously made a new application, but we didn't. We didn't want to. And indeed, we would have had a real problem if we'd done that, because the analysis in the first decision was unlawful. That was our claim, and that was ground one, and that is what the evidence went to. So if you make a new application and you don't challenge a decision that rejects your account for all these reasons, then that is the starting point of the new application. So it's really important. My learned friend took you, for example, to paragraph 44 of the witness statement and suggested this was new evidence. But it isn't new evidence. It is precisely what a judicial review does on a common law challenge to a decision. Says you have said X, but that's actually wrong. That's not what the evidence before you showed. It's the essence of an irrational decision or not properly considering the material before you, and that was ground one. So saying that the 44 records, for example, my answer is recorded as no. That's his answer in the interview before the decision maker. He says, I never said we didn't have any issues. I have always said we are using a mix of Urdu and English. It's not new evidence. It's what he's always said. It's in his previous evidence. What he's pointing out is that the decision is flawed. Yes. And this is that's why you cannot simply say, oh, it's new evidence, and therefore it is the type of new evidence.
What about the screenshots, though? That looks a bit more like new evidence.
The screenshots are new evidence, but as I said, they are in the same vein as the previous evidence. So they are similar to the MRLP life evidence and the Red Cross evidence.
But they're new. They are new evidence.
They are new evidence.
And it might be thought they're quite striking.
Well, so is the previous evidence quite striking. It's at the same time, and he's saying my wife is missing to other people.
So this is new evidence, but it's simply in the same vein as the previous
It's absolutely in the same vein.
Right.
And there's absolutely no mention of it anywhere in that disclosure. Nothing. There's no mention of that. There is mention of the old similar
in the disclosure
evidence.
of the Secretary of State's reasoning. In the disclosure of the Secretary of
Exactly. In the disclosure of the reasoning. Now, the second point to make, so and it is really important because this is where, in my submission, the real problem has come in. Just saying it's new, yes, it's a statement, it's new. These are actually a lot of the points could have and were made in the PAP. That's the other thing. If you read the PAP and you read the statement, it's the same points. It's just the applicant saying your analysis of my previous information is unfair. That's effectively what that evidence is, and that is not the type. That is the type of new evidence that explains why a decision's unlawful. There's no bar to putting in a witness statement with a judicial review that analyses the legality of a decision, and that's effectively what the vast majority of that statement is. Now, so we didn't put in a new statement, a new application. The Secretary of State, if her position is that absent a new application, she could have defended the claim, and that's all that made the difference. She could have defended the claim and said we're not going to look at any of this. She had the Article 8 grounds and the Article 14 grounds at PAP stage. Indeed, she had it all in the previous judicial review. So that's no reason for the late material. But also, this material doesn't go. This material goes to why that decision is unlawful. So it.
By this material, I mean the PAP letter and the.
Yes, it wouldn't have helped unless you accept that there was a problem with the previous analysis. It doesn't help. So the second point is there's been a lot of explanation now for why, oral explanation for what the Secretary of State was doing, or it was being suggested that she didn't even consider the evidence with the PAP, or that she didn't take it into account. There were then various submissions detailing why she did what she did at what time. There is simply no evidence before you to support that. If the Secretary of State wanted to say that when she got the PAP, she didn't actually consider the material with it, then it has to be in evidence. It should not be in oral submissions. And indeed, if the Secretary of State wants to explain the concession, and it's important because it's in a context where we repeatedly ask for disclosure up until we've been asking for all the material underlying what has happened, because we did not accept the analysis that was being put forward. So we said we want the case working notes, we want to see what the Secretary of State was doing, and we were told it wasn't relevant.
And privileged.
All privileged. Exactly.
Yes.
So it's either you disclose it and we can see it and we can make submissions on it, and you can, even privileged information, if you want to, you can disclose it for the purpose of cost. That's the decision for the Secretary of State. But to then suggest what it might say without any evidence or disclosure in my submission is not an appropriate approach. With respect to the Article 14 ground, my learned friend accepted that she'd have to do a new balancing exercise if she accepted the evidence and the relationship. So the Article 8 ground is an individual ground. You simply cannot say one way or another whether we might have won or lost on that ground. Certainly not on the basis of a completely different case. But even my learned friend's submissions today, she said they didn't get onto that, but they would have had to do that if they hadn't conceded on the rules. This point that she only decided to concede later, in my submission, just doesn't really make sense. The ambiguity was there, we argued it, and we succeeded on it. And
Yes, so I was going to just raise this. Given the concession on the ambiguity, you won on it.
We won on it, exactly. In fact, it went, the concession, the written concessions actually went further than there was an ambiguity. But the written concession said that we would be granted under the rules. In fact, we ended up being granted outside the rules. But again, those points, there was never a challenge to the rules. There wasn't anything that would have survived. We didn't challenge the rules. We challenged the Secretary of State's application of the rules to us.
I accept that.
Yes, so there wasn't something, my learned friend started to suggest there was something that could have survived even if the concession had been made earlier, and there wasn't. But similarly for Article 14, it's important, and I have to show you the grounds very briefly, but at paragraph 82 of the grounds in the core bundle, page 173, and it's tab 18.
Thank you.
You can see that there was a difference, as I said, to LR's case. We were being treated differently.
Paragraph
82.
So 81 is the same challenge as LR.
Exactly. 81 is the same
discrimination
challenge.
on grounds of nationality.
Exactly.
But 82 is discrimination on the grounds
Exactly.
you've lost your spouse.
We ran it in both ways because we didn't know if we'd succeed on the wife. But once you succeed on and we succeed not because of a grant at someone deciding to be nice to us, but because the account we've told of a really tragic incident that had different legal ramifications for us had been accepted as true. We've been accused of lying about that effectively in the refusal. Now it's accepted it's true. And then the discrimination claim falls into the alternative basis, which is a completely different basis to LR. So it has not been decided. And you can see then further as you go down, 83.1, we talk about the fact that the errors in ground one affected the findings because one of the analogous factors was that he didn't have a permanent residence card, but we would say, well, he'd explained in his early evidence that he'd been planning to stay permanently because he was married. So it was a matter of finishing his student visa and then switching. So
does it all come down to this? The decision on the what you say is the principal issue, the question of the subsisting relationship, meant that the whole issue of Article 14 fell away.
It did fall away, but had it not fallen away, the reversal on the wife, let's say the Secretary of State had maintained that the rules, her position on the rules, so they'd accepted the relationship with the wife was subsisting. They'd said, but we don't accept you should be granted.
Then you would have had the article.
Then we would have had the article, but it would have been a completely different argument. That would be the basis for the Article 14 argument. That's the only basis worth looking at this point, because the court would never consider the Article 14 argument on a basis that the wife was not in a subsisting relationship, because that's by this concession been established, and so the basis would have been very different.
Had she accepted the subsisting relationship but not accepted the argument on the rules, then the Article 14 issue would still have subsisted.
It would have subsisted but been determined on the basis that the relationship was subsisting.
Yes.
Which is different to the LR discrimination, because you have a completely different point that you're analogous to other third country nationals who are coming, which is the point, which is actually the same point as the rules, that we were saying we shouldn't be penalised under the rules because our wife went missing when we would have been able to.
So does it follow that?
If our
I'm
wife
sorry to
hadn't
harry
gone
you, but does it follow therefore that the ambiguity concession is the crucial turning point in that respect? Because once that was conceded, once the rules point was conceded, then the Article 14 point did fall away.
Yes, and the Secretary of State said that. They said that in the application. Once they conceded it, they said the only thing that matters now is ground one.
Yeah.
But
That's not strictly true, because you'd still have the LR point. But we know you would have lost on that if it had been fought out.
But we wouldn't. The argument would have been on the basis that our wife was there. So our comparator would have been different.
Yes.
We have to argue it on both bases when it's disputed.
I understand that.
But once you get to that point, but the other thing, and I want to show you just 88, that the whole, what the balance, as Bank Mellet makes clear, you both balance the justification and the impact of the discrimination on the applicant. And we were relying on his wife going missing and how that affected him as part of the argument.
Article 8 balance.
It affects the Article 14 balance, because if you have a justification that you have to look at the individual facts.
Yeah.
And paragraph 90, we make clear that we're not challenging the rules, we're challenging the individual decision in his case. Now, we weren't challenging. Our challenge was, in our case, the discrimination was not justified.
Okay.
We were not saying we want the rule. That you see, the remedy is not that the rules should be struck down.
Yeah.
So
how does that? How should a judge deal with? There are all these loose ends which are raised in the claim, but all fall away.
yeah.
How do you say a cost judge should deal? A judge should deal with that when making the cost decision.
It's effectively the Viridor waste approach, which is, in this type of case, where you didn't lose anything, it shouldn't affect the cost. Unless, maybe there would be a case where it was really clear that all the evidence went to one issue. And, I mean, it's hard. In this type of case, it certainly shouldn't affect cost. We haven't lost on anything. Grounds became academic, and there's no evidence to suggest that we unreasonably, it's when you unreasonably pursue a point effectively, and that if you unreasonably pursued it, even if it wasn't determined against you, then that would be a justification for reducing costs. But there's no suggestion that we pleaded something unreasonably. And in this type of situation, it would therefore not reduce costs. What Viridor Waste says is that even if you have two issues and you lose on one of them, then your costs may be reduced if there wasn't complete overlap in the evidence. So if it was a separate issue that required a separate evidential response and a lot of different work, and you lose on it, then you would lose part of the additional costs. So in that case, they gave the example that if you were
We haven't looked at Viridor Waste.
it's 16 to 18, I believe.
Tab 5.
Tab 5.
And it's my lord.
Yes. And you see, in the example given is that if 70% of the cost.
Which paragraph are you in? It's 18.
18, exactly. So if you imagine there's all the general costs of bringing a claim. So if, for example, 70% of the costs were common to both issues and they were 50-50, they incurred 50-50, the extra cost should be a reduction of 15%. Now, that's an example where you go to trial and you lose on an issue that took up half the time. We're just not even anywhere near that type of situation. And we've had a 25% discount. So it's not in line with the authorities. And the judge didn't accept, in my submission, it's not clear that the judge accepted any arguments that we had, that there were remedies that we could have pursued and didn't, or somehow lost on. In the sense, the partial success. I don't accept that you can read into the judgment that there was acceptance that because of the Article 14 ground, for example, that's why costs should be reduced. You would expect the judge, if that was the reason for the significant reduction, you would have expected that to be said.
Yes.
So I think I should. The only other point I want to say is it was this point. It's a small point, but there was not a fresh decision. It was said that there was going to be a supplementary decision. That was meant to be a decision that built on. That normally means something that builds on. This is one of the things that Karupen.
Well, Karupen says it's used in a number of different ways.
It can be used in a number of different ways, precisely. But that this is post Karupen, and it's Karupen said be clear about what you're doing. And again, I don't accept. There's a lot a lot added to what was said about the judicial review. What the extension application actually said is there are matters raised in the grounds. Those are pleaded grounds about why the decision is unlawful, as that new evidence was about why the decision was unlawful. My learned friend, the Secretary of State did not need to reconsider because we could have made a new application and we decided not to if our grounds did not have merit.
It's not that you've produced some startling new piece of evidence which had never been produced before.
Yeah.
It's that you have put forward material which you say supported the grounds you'd pleaded as to why it was originally unlawful.
Exactly. That was the vast majority of it, and the only bits that weren't were not things that the Secretary of State relied on in the new decision. There's no evidence that she did. My learned friend hasn't even suggested that she did. He hasn't shown you anything.
Can I ask you something else? I don't think it affects anything we have to decide, but just a matter of interest. One of the points you've made is that these decisions are very important for legally aided practices.
Yes.
And have I understood it correctly that if you get costs from the other side, you receive more money than if you get costs you just get a legal aid assessment?
Definitely, yes. You get your.
What are we talking about in terms of the amounts at stake here?
It depends whether you're on a very high cost case plan or not. I think it could be the difference between £50, say, and 350 or 400, depending on what your commercial rates are. It can be that sort of difference. So it can be 7 or 8 times.
Presumably your inter partes costs are assessed on the standard basis. So if there's a challenge, they all get assessed, and you get paid what, at normal commercial rates? You
get paid at normal commercial rates, but there can be arguments about whether the rate's reasonable. There can be arguments about each bit of work.
How much time
the reality is you normally have about 20% knocked off. That's just the reality. But the difference, the legal aid rates, I don't know the exact rates, but when you're not on a very high cost case plan, it may be £70, £75 an hour. It may be.
But it's still, I'm sure.
There doesn't seem to be any dispute about it.
It's a significant difference, but it's significant difference.
It's between 3 and 5. I'd say it's somewhere between 3 and 5 times different. And it matters in principle, obviously, but because it affects other. If there are patterns.
Yes, it doesn't affect the client at all.
It doesn't affect the client.
But it affects the viability of the firm.
No, unless the client were to come into money and have the.
Oh, yes.
Yes.
Legal aid charge.
Yes, but I don't read. That's yes.
Thank you.
Anything else?
No, those are my suggestions. Thank you very much.
Well, thank you both very much for this interesting argument. Cross cases are sometimes rather dry, but this one was full of interesting little avenues and well argued, if I may say so, and well prepared by those who sit behind you and prepared it. So we're going to reserve our judgments in this case. In due course, you'll get a draft judgment, which will give you an opportunity to correct any typos and not to re-argue the case. Please bear in mind the rubric at the top of the draft, which prohibits the disclosure to anybody else other than those of whom notice we've been given. When you get our draft, we'd be grateful if you would agree the terms of an order that reflects our decision. It occurs to me that there may be at that point an issue. At the point I don't want to get into it now. The point that Mr. Holbin's raised about the time on which costs should run. I'm not asking for submissions about that now because I don't want to anticipate what we may or may not decide. But that might be an example of the disagreement about you as to the terms of the order. If there is a disagreement, please can we have short written submissions and we'll resolve it on paper. Thank you very much.